You didn't think that discovery was going to be exchanged peacefully in this case, did you? Attorney Robin has filed a motion to compel. Essentially, she is asking the court to order Tim to provide answers and/or documents properly. Not because Tim didn't respond or answer, but because according to Attorney Robin, those answers are either incomplete, evasive, unverified, or improperly objected to. As always, I am a certified law nerd, bona fide non-attorney. This is not legal advice, just my interpretation of what I'm reading in the record. So let's break it down. As I said earlier, a motion to compel is a request for the court to compel a party to provide discovery that the other side says is incomplete or missing, or legally insufficient. This is governed by Rule 37 in North Carolina's Rules of Civil Procedure. So again, there's a lot outlined in that. I'm only showing you a screenshot, but it goes into everything from what qualifies to what can be done, and then, of course, what sanctions would apply if applicable. Under this rule, an evasive or incomplete answer can be treated as a failure to answer, which means the court can treat an incomplete or evasive response the same way it would treat no response for the purposes of deciding whether to order better responses. If the court grants this motion, attorney fees can come into play, and if a party later violates the court's discovery order, then sanctions can come into play, which again are fees and penalties imposed by the court. Now, the motion itself is only 2 pages long. The rest are exhibits attached. But in paragraphs 6, 7, and 8, we get to the core of the motion. Attorney Robin says that on or about April 11th, Tim sent answers to plaintiff's first set of discovery, but she says those answers were unverified because there was no verification page attached. That creates a problem because interrogatory answers are supposed to be sworn testimony. So from the plaintiff's side, they are saying they were not properly verified discovery answers. Then in paragraph 7, Attorney Robin lists the interrogatory she says Tim failed to answer. Those are interrogatories 3, 4, 12, 13, 14, 18, 27, 36, 37, 38, 39, 42, 43, and 44. Then paragraph 8 says that Tim also failed to respond to specific document requests, including requests 1, 2, 4, 5, 6, 7, 8, 9, 11, and 12. In lines 9 and 10, Attorney Robin says her office tried to resolve the issue directly before bringing this to the judge. Paragraph 9 says her legal assistant sent Tim a good faith email and letter on or about April 27th. Paragraph 10 says that on May 7th, Tim replied and maintained his objections. That gives the court the procedural timeline, and the attached good faith letter says exactly that. It identifies the same allegedly deficient interrogatories and document requests, says the discovery is directly relevant to the alienation of affection and criminal conversation claims, and warns that if complete responses are not provided by May 7th, Attorney Robin would file a motion to compel, and that she did. In the prayer for relief section, this is what Attorney Robin is asking the court to order. First, she is asking the court to compel Tim to serve responses to Devon's first set of interrogatories and first request for production of documents. She is also asking the court to order Tim to pay Devon's costs and attorney fees associated with bringing this motion to compel. Under Rule 37, again, if a motion to compel is granted, the court can order the party whose conduct made the motion necessary to pay reasonable expenses, including attorney fees, unless the court finds the failure was substantially justified or that another circumstance would make that award unjust. If this is granted, Tim will likely have to foot the bill for this motion. Okay, so what happens next? Based on what is written in this motion alone, the court may grant it, deny it, or narrow discovery, especially in areas where the court may decide a request was too broad. The court can also set this motion for a hearing, where Tim can make the legal arguments for why he believes his objection should stand. My personal read, I would not be surprised if the court ordered Tim to supplement at least some of these responses, or beef them up, if you will, especially around the issue of verification. According to the motion, that is a critical required step that needs to be completed. I would also not be surprised if the court looks at missing responses or anything it views as incomplete and orders him to provide more complete answers. And I would also not be shocked if the court narrows a couple of the requests. Remember, it's not always all or nothing. Sometimes there are partial wins in motions like these. So it could be the court deciding, Tim, you need to answer this, this, and this, but we are going to narrow this other request. This objection is valid, this answer is incomplete, and this one is evasive. Do keep in mind, if a discovery order is violated after the court has already compelled someone to answer, That's where those Rule 37 sanctions become a much bigger issue. Now, the request for production and the actual interrogatories are attached as exhibits, but I will not be covering all of that in a video because this is 32 pages long. I think I'll read those on a live because the questions get into finances, communication, social media, leases, living arrangements, witnesses, relationship timeline. That's a lot. That we would be here for hours. Yeah, I should have known that there would be a discovery fight in this case. As always, we'll continue to check the docket and I'll come back to you with updates. I'll catch you in the next one.